I am Alfred Tengbe. Today I bring you the usual lectures from the law basket. And today I'll be discussing about the recent law in our jurisdiction, which is the Cybercrime Act of 2020. We've had so many critiques going around with regards to the Cyber Act, and today, courtesy of the law basket, I bring you these lectures trying to talk about the purpose and effects of the Cybercrime Act of 2020. Now, one may want to ask, first of all, what is law? Law, in brief, is a mechanism that is used for the dispensation of justice, which is what the authorities in charge say it is. Now, one may want to ask the question, who are the authorities in charge for the making of the laws? Now, for the purpose of the authorities in charge, for the purpose of making the laws, we're not going to talk about those who pioneer the bills in Parliament. Neither are we going to talk about those who implement the law, who are just going to follow the procedures imposed to be followed by the lawmakers. For today, we are going to focus on those who actually make the law and those who interpret the law. Now, if we take a look at those who make the law, as a first link to be discussed, who are the people that make law, that are responsible to make law in our jurisdiction? If you take a look at section 105 of the 1991 Constitution of Sierra Leone, which is a ground norm in our jurisdiction, it makes provision that Parliament, the legislative arm of government, is the supreme authoritative body that is responsible with the aspects of making laws in our jurisdiction. And their purpose, the exercising of their responsibilities, which is the making of those laws, shall be made through the process of a bill. A bill will be pioneered to Parliament, of which we go through processes, like we have the first reading, we have the second reading, we have the committee stage, we have the third reading, then before it moves to the presidential assent. And whereas the bill has been passed by Parliament, that is pursuant to section 106, subsection 1 of our Constitution, it requires the presidential assent on it before it can become a law in our jurisdiction. However, it is worth knowing that where there is absence of the presidential assent, then this bill can be voted, an election can be conducted in Parliament. And whereas 2/3 of the majority of parliamentarians vote in favor of this bill, then automatically it becomes law and binding in our jurisdiction. This is in accordance with section 106, subsection 8 of the 1991 Constitution of Sierra Leone. Now, coming to look at the Cybercrime Act of 2020, one may want to ask, is this act legal? Of course, yes, because it has satisfied all the procedures required for a bill to become a law. So it is legal and binding in our jurisdiction. And this Cybercrime Act is a good law because it gears towards protecting the misuse of computer data. It prevents people from the misuse of the computer data. But now the question to be asked about this law is that, what is the degree of punishment upon the breach of any provision of this statute? The degree of punishment required for any breach of such provision or any provision of this statute is not certain. Rather, it left all the burden on the minister in charge to determine the degree of punishment. Who is then the minister in charge? If you take a look at section 1, which is the interpretation section of this statute, which is the Cybercrime Act of 2020, it refers to the minister as the Minister of Communication. That is to say, the Minister of Communication is the one responsible to determine the degree of punishment upon breach of any provision of this act. Now, this provision is very ambiguous. Let's take, for instance, section 5, subsection 7 of the Cybercrime Act of 2020, which makes the same provision that the minister shall be the person to determine the degree of punishment required upon breach of any provision of this statute. And this should be done in accordance with the regulations made subject to this act. It is what for the general populace to know that the acceptance of this act means the regulations coming after this act all are accepted. And every regulation made subject to this act by the minister are all legal and gain legality in our jurisdiction. Now, the minister can wake up in the morning and refer to a breacher of any provision of this statute that you are sentenced to a term of imprisonment, which is life imprisonment. Because it is discretionary, it is left with him to determine the degree of punishment upon breach of any provision of this statute. That is to say, the general populace is left in a dilemma. They lack certainty as to the punishment required upon the breach of any provision of this statute. Say section 5, sub 7, subsection 8 of the Cybercrime Act of 2020, rolling down to section 31, 32, all the punishments, I would say all, if not all, but most of the punishments in this statute are ambiguous, are vague, they are not certain. Rather, they are to be determined by the minister in charge, who is the Minister of Communication. It creates room for administrative errors. So, accepting a law which is not certain as to the degree of punishment creates room for there to be a risk of the arbitrary use of power, which is in violation of one of the fundamental principles or elements of the rule of law, that is the supremacy of the law. The element of supremacy of the law means that it is the law that is supreme and not man. So by giving all those powers to the minister to determine the level of punishment may create room for a minister to use his discretion by saying or providing immunities for all government officials, and then leaving the layman to be subject to such punishments that he may prescribe by his regulation. And this go against another element of the rule of law, which is equality before the law. The element of equality before the law requires that every human being should be treated equally by the law. And now by prescribing that all government officials should be immune from punishment, unlike the layman who should be subjected to such punishment, violate such elements of the rule of law, which evidence aimed and geared towards eradicating in his publication of the principle of the rule of law. Also, if you take a look at the issue of the separation of power in the context of this Cybercrime Act of 2020, if you take a look at section 53, subsection 1, which makes provision for the executive arm of government that is responsible to implement the laws of the state. They formulate policies and implement the laws of the states. And section 73 of the Constitution makes provision for the legislative arm of government. They make and unmake the laws of the states. Whereas section 120 of the 1991 Constitution makes provision for the judiciary arm of government that is responsible to adjudicate the law, to adjudicate and punish lawbreakers within the states. Now, giving the Minister of Communication the powers to determine the punishment of anybody that breaches the provision of that statute means the minister therein now is performing the adjudicative power that was allocated to the judges. It is the judges that determine the punishment and term of imprisonment upon breach of any law, and it forms part of the adjudicative power that is vested in the judiciary arm of government. So the minister, who is part of the executive arm of government, performing or giving the powers to perform such role means it violates the principle of separation of power, and then it usurps the rule of law, especially the issue of the supremacy of law, making the minister supreme other than the law. So our parliament, by accepting a law that is not certain as to the punishment required upon breach of any provision of that law creates room for uncertainty and dilemma to the general populace. And the general populace should be cautioned about this. However, as said earlier, the act is a good act because it gears towards the protection against the misuse of computer data. And it is legal in our jurisdiction because it has gone through all the processes required of a bill to become a law. But the vital position that creates room for uncertainty or that should have been questioned by the parliamentarians is this issue of the degree of punishment required upon breach of any provision of this law. The issue of the breach of any provision of this law is uncertain and ought to have been questioned by our honorable parliamentarians. There may be other attention-grabbing provisions in this statute, but for the purpose of this video, these are the highlighted one, especially the degree of punishment. And I invite you all to like our video, subscribe to our channel, and share. And don't forget to click on the notification button for you to be notified upon any new upload of our videos. Thank you very much.